Hey guys, Easy Hack here, and today I just thought I'd get into some small claims. So you might have to maybe take somebody to small claims court someday. You got to stick up for what you think is right, right? So here's a small claims manual, 2022 application. A manual, important information about suing in small claims court. Introduction. Definitions before you file a claim. What you can and cannot sue for in small claims court. Location, venue for filing your claim. Parties to the suit. Change of address, email, or telephone numbers. Deadlines for filing suit. Statute of limitations, filing a small claim, representing at a trial, attorneys, corporations, representing in a small claims court, sole proprietors, proprietorships, unincorporated businesses, counterclaims, trials, jury trials, settlements, change of judge, trials, burden of proof, witnesses. Burden of proof is on you to prove that you are owed an agreement was broken and you are here for a good reason, right? So, application of manual. This manual has been prepared to provide you with general knowledge and Operation Small Claims Court in the Circuit of Superior Court. It does not address specific jurisdictions, procedures. So basically, this is just a quick guide. It's not exactly right to the T. But important information is about suing in small claims court. Small claims have simple rules and procedures and allow you to represent yourselves without an attorney. As a result, many of you may feel that all you need to do to win your lawsuit is to appear in court on the day of the trial. Others may feel that it is the judge's job to develop and help you present your evidence at trial. Still, others may believe that in some magic associated with the courtroom or with that judge process supernatural insight in which enable him or her to find the truth without the benefit of evidence. None of these beliefs are correct. You need to prove your case. You need to prove that you are just not wasting everybody's time and money here, in that this has been costing you time and money and has been causing you pain and suffering. That is up to you to prove. Like any tool, the end product will show your skill in using the tool. So this is just a tool. Proper preparation and efficient presentation for your claim and evidence is greatly increased in your chances of winning a small claim court. This is a little test too. Introductions. The small claim court allows every citizen to bring in a lawsuit in an informal manner and does not require that a party hire an attorney. You may hire an attorney if you want. However, in most instances, you're not able to get that money to pay your legal fees to hire an attorney. And the small claims court are created so that you would have a speedy, reasonable, inexpensive, uncomplicated means of determining your claim. It is for your benefit. Do not be afraid to use it. The court staff and clerk staff will assist you, but they cannot give you legal advice. The procedures are not complex. The plaintiff fills out a simple form stating why the defendant owes him and her money of the defendant property which should be returned to the plaintiff. Each party will explain his or her side, and the judge will then judge the case. And that's pretty much it. Like, you write an affidavit of debt, agree, pre-trial, body attachment, contempt, continuance, all this stuff, damages, default judgment, all this stuff is here. Keep reading on, guys. Garnish defendant, injuries, notice of claims, open an account. Now, this is all like everything. So, before you file your claim, does the small claims court have the authority, jurisdiction to hear your case? See pages 11 and 12. In this country, the proper location venue for filing your claim. Who are the parties to the action? Is it too late under statute of limitations to file your claim? What you can and cannot sue for in the claims court. Personal injury, $10,000 or less. Damage to personal property, real estate, $10,000 or less. Landlord and tenant disputes. If the rent due at the time of filing is $10,000 or less. Money owed, bad checks, wages, services rendered, accounts, receivables, $10,000 or less. Return of wrongfully taken property and return of money paid for. That is what small claims court is for. Faulty work, $10,000 or less. Emergency property actions between landlord and tenant under whatever thing you have. Location, venue for filing, where it happened, okay? Change of address, email addresses, you notify everybody. And yada yada yada. Filing a small claim. If you wish to file a lawsuit against, you must follow these rules. You must fill out several copies of notice of claim form by briefly and clearly stating in writing the nature and amount of your claim against the defendant. You will have an opportunity to explain more fully in court. Notice of claim forms are available from clerk's office without charge. If your suit is based upon a written contract, you must provide the clerk of the court one copy of the contract for the court's records and one copy to each defendant that you are suing. If suing on an account, you must file with the notice of claims an affidavit of debt. The current form is provided at whatever you want. Go search it for yourself. You must give the clerk correct name, address, telephone numbers of the defendant. Be sure the named defendant is the real party in interest. That is very, you are wasting your time if you bring the wrong party there. For example, following an automobile accident, you should sue the driver of the other vehicle, not his or her insurance company. You must pay the cost of filing the suit, regardless of whether you have the notice of claim delivered by certified mail or to have a sheriff deliver it to the defendant. If you win your suit, the defendant will be ordered to repay the money to you. You will not be repaid if you lose. If you are filing an action in small claims court, you waive any claim in excess of the current jurisdictional limit, $10,000. You may not later bring a separate action for the remainder in another claim. If you have a question about the procedure, you must follow any other matter relating to your case. Ask the clerk for some help. And the clerks are awesome. Hearing, you should check with the court staff to find out if you will be expected to have all your witnesses and evidence with you on the trial date. In many courts, the first trial date is used merely as a date to find out if the defendant is going to dispute your claim. If the defendant does not show up for his first date after receiving proper notice from the clerk, or if the defendant does not show up, you can work out some agreement, then no trial will be necessary. On the other hand, if the defendant does dispute all or part of your claim, the judge may set aside for trial for a later date. Notice the suit must be served upon the named defendant at least 10 days before the parties are to appear in court. If the clerk or the sheriff is unable to find the notified defendant the lawsuit within the time, you may either dismiss the suit or request a continuance of the trial date in order to have more time to notify the defendant. Okay, so yeah, it's basically sensible. And that's all I'm going to tell you right now. You can get this off the internet for yourself. Have a good day. Easy hack out. Don't let people use you. Sue them if it's worth your time. And have a good day. If you have any questions that you want me to go over, ask them, and I will look up the questions and give you a great answer. Right now, I'm looking into suing somebody that illegally towed my truck, insured and on the road truck, out of my backyard when I was off my property out of town. And they tried to say the by law enforcement guy, and the landlord just wants my antique Cummins Dodge truck. Anyways, have a good day. Bye. Stop recording.